Doctors, did you know that you were done out of a long-term employer relationship for your career just to cover up my whistleblowing case and prevent it being heard by a court? Now, it's important for a doctor to be able to demonstrate their long-term employer status in order to get a good deal on a mortgage or other financial product. So how did HE or the deanery do this? Well, in my case, they came to court with misleading arguments about their actual influence over a doctor's career and employment. They also astonishingly hid a contract that proved HE employed junior doctors long term. Unfortunately for them, a Telegraph journalist has found this hidden contract and sent it to us. So we're going back to court this November to ask HE and their lawyers about this hidden contract proving HE as an employer of junior doctors. Now, their lawyers ought to know about this contract because they were paid to draft it in 2014. This is a really big deal. It's even been discussed in Parliament.
Where Health Education England were effectively seeking to remove around 54,000 doctors out of whistleblowing protection by claiming that they were not the employer. 4 years and hundreds of thousands of pounds later, they eventually backed down and accepted they should be considered an employer after all. I'll give way.
I'm very grateful to my friend for giving way. Is he aware that a contract which was between Health Education England and trusts, which demonstrated the degree of control that Health Education England has over the employment of junior doctors, was not disclosed for some 3 years in that litigation. And it was drafted by the very law firm which was making loads of money out of defending the case against Chris Day. And when I raise this with Health Education England, they won't give me a proper response because they say the case is at an end. Does he agree that this is totally unacceptable and that it smacks of unethical behaviour by the law firm to make money out of not disclosing a contract that they drafted themselves?
So why would HE want to argue the nation's doctors out of whistleblowing protection and undermine their long-term employment status? Well, you'd have to ask them that, and we intend to, in court.
£700,000 of public money was spent by the NHS in defending against that claim, in large part attempting to deny junior doctors whistleblowing protection against Health Education England. Lawyers, disgustingly, were enriched.
I asked the former Health Secretary, Jeremy Hunt, about all of this and even met up with him in his office. We discussed the possibility of all this amounting to a contempt of court. He promised to look into it, and then a few weeks later, he became the Foreign Secretary.
Good afternoon, Mr. Hunt. My name's Chris Day. I'm a junior doctor. I'm going to be nice to you, I promise. So my question is about whistleblowing and patient safety. I know that's an issue close to your heart, which is why this question you may find somewhat inconsistent to your position. So in February 2015, within 2 weeks of the Francis report being published, legal arguments were advanced to essentially prevent my whistleblowing case being heard by an employment tribunal, but had a more global effect on all whistleblowing protection relating to junior doctors. And now a Court of Appeal judgment has also confirmed had an effect on hundreds of thousands of agency workers, thus depriving them of statutory whistleblowing protection by way of the Employment Rights Act. You may be aware of it. But it's essentially depriving hundreds of thousands of workers of statutory whistleblowing protection. So the Court of Appeal ruled that the arguments advanced by you and HE were legally flawed and essentially threw them out a few weeks ago, which you may or may not be aware of, but I'm sure you are. How is that consistent with anything you've said?
Well, first of all, I know that you've championed the issues around whistleblowing consistently over a long period of time. And from my perspective, one of the central changes that I want to make in the NHS is to make it a more open system where it's easier for people to speak up when they have concerns.
So what was it in my case that worried them enough to blow 700k and argue the nation's junior doctors out of whistleblowing protection? Well, my case centres on the NHS response to serious concerns I raised about intensive care unit staffing levels and airway support. After I raised them, they became associated with 2 serious untoward incidents involving the deaths of patients.
Scroll forward now to 2013. Dr. Chris Day, a brave junior doctor working in a hospital in South London, raised safety concerns about nighttime staffing levels in an intensive care unit. Now, it's in all of our interests that if there are concerns about the safety of any part of our health service, but perhaps particularly an intensive care unit, that brave people speak out. But what happened to him, because he spoke out, was unacceptable, wholly unacceptable. He suffered a very significant detriment. His whole career has been pushed off track. His young family have been massively affected by this. The junior doctor in that unit was put into an invidious position, being responsible for far too many people compared to national standards.
So in October 2018, I came this close to cross-examining all these people about what they have done with this case.
Last year, the tribunal that eventually heard his case ended early after Dr. Day was threatened with a claim for substantial costs. He and his wife couldn't face the prospect of losing their home for their young family, and so he caved in. It is surely a scandalous treatment of a junior doctor. He was defeated by superior firepower. We have the grotesque spectacle of the NHS of all organisations deploying expensive QCs to defeat a junior doctor who raised serious and legitimate patient safety issues.
So the NHS used cost threats against me and my wife and wasted cost threats against my legal team to force the settlement of my whistleblowing case, to prevent me cross-examining the NHS's 14 witnesses, and then the cost threats were used for a whole day to force me to make a public statement stating that I believed the NHS had acted in good faith in this case. Astonishingly, the NHS has denied that costs were used in this way or at all to MPs and to the press, and have stated the claim that I say they were is simply untrue. It is obvious that not everyone can be telling the truth about the way this case settled, but successive judges have turned a blind eye to this fact and have refused to allow me to set aside the settlement agreement. In another twist, earlier this year, I was granted permission to appeal the settlement agreement in my whistleblowing case by Lady Justice Simler of the Court of Appeal, only to be told a few weeks later that her signed and sealed court order granting me permission to appeal was in fact a clerical error, and the actual decision of the court was to chuck the appeal out. Her reasoning is brief to say the least and doesn't really deal properly with any one of our grounds of appeal. I can tell you, as a doctor, if I signed the wrong drug for the wrong patient and expected to claim it as a mere clerical error, I would be laughed out of town. So we're going back to court for 3 hours on the 13th of November and for 15 days from the 1st of March next year. If you'd like to help and support us, we'd be very grateful.